Good morning. I'll ask the fifth elected member from the District of Georgetown to say prayers today.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations, for the glory of thy name, and for the safety, honor, and welfare of the people of these islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established amongst us. Especially we pray for the Governor of our islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of Cabinet, ex officio members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
Please be seated.
The Lord bless us and keep us. The Lord make his face shine upon us and be gracious unto us. The Lord lift up the light of his countenance upon us and give us peace now and always. Amen.
Thank you. We certainly couldn't be seated without that blessing. The House is now resumed.
Administration oaths and affirmations.
None.
Reading by the Honourable Speaker of messages and announcements.
I'd just like to put on record, I'm sure the House would mind on behalf of all members, our sincere congratulations to the Honourable Deputy Speaker on receiving his award last night from the Adventist Church for all of his invaluable work to that community, and specifically to the Savannah Adventist Church.
Presentation of petitions.
None.
Presentation of papers and of reports.
None.
Questions to Honourable Ministers and members of the Cabinet. The Honourable Leader of the Opposition, the first elected member for West Bay, to ask the Honourable Minister of Financial Services, Commerce and Environment, question number 43.
I recognize the Honourable Leader of the Opposition.
Madam Speaker, it's possible that events have overtaken this matter since the House been out for so long. Nevertheless, I beg to ask question number 43, standing in my name, which reads as follows. Can the Honourable Minister say if he received a letter from the Foreign and Commonwealth Office, officials, or the Minister in charge indicating they wish to proceed with gathering of personal and private information on all Cayman citizens, companies, residents, and other residents doing business in the country, with such information to be shared in a database with access at will by the United Kingdom law enforcement?
Honourable Minister responsible for financial services.
Good morning, colleagues. Madam Speaker, the answer. The member appears to be referencing the ongoing discussion between government and the FCO on the sharing of beneficial ownership information between law enforcement and tax authorities in Cayman and the UK. There have been several letters over the last few years on this topic, but none have referenced the gathering of personal and private information on individual Caymanians and residents. The issue has always been about the transparency of the natural persons who own and or control the corporate and legal entities incorporated locally that conduct international business, and the sharing of identity information in cases where there are legitimate law enforcement or tax authority investigations underway. As was announced on April 11th, the government reached an agreement with the UK that we will not have to create a central database that would be directly accessed by law enforcement in the UK. Instead, there was an acceptance by the UK that the Cayman Islands would continue its current regime of having verified beneficial ownership information collected and maintained by our local corporate service providers. Government has proposed a technology solution that would allow specific searches of this data by our local law enforcement agencies. Through a local designated point of contact, requests from UK law enforcement would then be handled. There would be no external direct access. Thank you.
I recognize the Honourable Leader of the Opposition for supplementary.
Thank you, Madam Speaker. Madam Speaker, as matters stand under the Tax Information Exchange Agreement, any request for an individual information must be notified by the individual, who then has the opportunity to challenge the application in court. That is under the Tax Information Exchange Agreements. This prevents fishing expeditions and ensures that there is due process. What safeguards with regard to due process are included in the proposals the Minister is talking about?
Honourable Minister for Financial Services.
Madam Speaker, I would be grateful for a moment to consult.
Most certainly.
Madam Speaker, the question initially referred to the Tax Information Exchange Agreement process or regime, and there was a statement made that the owner of the information was required to be told. That, Madam Speaker, is only potentially correct in the context of a non-criminal related investigation. Clearly, in a criminal context, you would not be advising the owner of the information that a request had been made. Certainly, that is the whole basis of the tipping off concern. But in the context of what has been agreed with the UK through the exchange of notes and the technical protocol, all of the, in respect of beneficial ownership, all of the normal protocols are in place to protect and give efficacy to the requests that are being made in respect of beneficial ownership. So the same types of protocols that existed or exist in relation to a request for information through the tax information exchange agreements, those same types of protocols would exist in relation to and are reflected in the technical protocols that have been exchanged with the UK in relation to beneficial ownership. All of the normal constitutional safeguards, Madam Speaker.
Honourable Leader of the Opposition.
Madam Speaker, if I understand the member, the minister, correctly, he is saying that due process is able to be had in non-criminal matters. I think that's what he's, in the gist of what he has said. Is it correct that foreign, and Madam Speaker, we have to probably read the exchange of notes between the government of the United Kingdom and the government of the Cayman Islands in respect of the sharing of beneficial ownership information to understand some of this. But nevertheless, from what I can gather, I need to ask these questions. Is it correct that foreign investigative authorities can inspect the register without notification to those whose information is being obtained? If notification is required, how much time, A? B, is there the due process that you have mentioned, where there is no warrants, no background reasons, if you take away the due process, that is, and no notification even after the event. But as I said, Madam Speaker, perhaps the public don't know because we don't have that in the exchange of notes so much in the public domain. While it is online, the general public perhaps will not know.
Honourable Minister for Financial Services.
Thank you, Madam Speaker. Through you, the exchange of notes and the protocol, as the member has indicated, has been published online, both by ourselves as well as the United Kingdom. In terms of his question, Madam Speaker, they cannot, the foreign tax authorities or law enforcement officials, well, let me confine it specifically to the UK, as it is the UK that we have the agreement with. They have to come and make a request through a local agency which satisfies itself that there is a proper rationale or reason for the request. It cannot simply be a fishing exercise. They must be satisfied that this is a legitimate and proper request. That agency, that local agency, then would follow up and make the necessary inquiries to obtain the information that is requested and then provide that information to the requesting party. In this case, it would either be the UK's National Crime Agency or its Serious Fraud Office generally, or its or the tax authorities in the UK. And so there's a clear understanding and a clear set of protocols which set out the fact that this cannot simply be a fishing exercise, that there must be some legitimacy to the request which satisfies the technical protocols and the exchange of notes.
Honourable Leader of the Opposition.
Madam Speaker, the exchange of notes says that the designated, and speaks to our designated point of contact. It says the designated point of contact will provide the information sought of it within 24 hours of the submission of a request for information unless it is notified that the request for information is urgent. Madam Speaker, that's question, part A of the question. Also, Madam Speaker, part B of the question is, was any consideration or has any consideration been given to the effect of hacking into this information, and who is to protect these families as we don't seem to have the resources to do that?
Honorable Minister for Financial Services.
Madam Speaker, in respect of the first part of the question, sorry, Madam Speaker, give me 30 seconds. Sorry, Madam Speaker. Madam Speaker, in respect to the first part of the question, the agency Sorry, Madam Speaker. In respect to the first part of the question, the notes do call for a specific agency to respond on this issue, on any request. That agency has not been definitively identified. There are one or two possibilities, but what is contemplated is that this will be resolved fairly shortly, and there have been discussions ongoing in respect of that. In relation to the second part of the question, what is contemplated is that there would be a 24-hour typical sort of response time. There is also a contemplation that it may be that in emergency situations there could be a 1-hour sort of turnaround time. We did not want to specifically oblige ourselves to a 1-hour turnaround time. So what is contemplated in the exchange is that there is some flexibility. The requesting party and the responding party here would be able to discuss and agree any circumstances which may mitigate the ability to respond in that sort of period of time. On the question of protection from cyber attacks, certainly that is a concern, but we have different groups who have been looking at this. We've been working with Cayman Finance, for example, who have a specific committee, technology committee, which is represented by or comprised of a number of representatives from industry who have expertise in these areas. And we're certainly very concerned about this to ensure that there is sufficient controls in place and sufficient protections to avoid that sort of scenario arising. Madam Speaker, one of the reasons that there has been a concern about having a central register per se is that very reason. Once you aggregate the data, then the potential increases significantly that if someone does get access to that centralized database, then they have the full picture. What we are proposing is a technology-based platform which will be able to go out and access information, relevant information, from the various corporate service providers. So the data itself is actually completely disaggregated. It is all separate and remains held by the corporate service providers. And we will just be able to access that information, or bits of that information as are relevant to the specific request. So clearly it's an issue that we are concerned with, but I think we're fairly confident that the way we have approached it already sort of minimizes risks in that respect, and we certainly want to make sure that any access platform has the necessary controls around it and protections built into it, which will minimize the risk of a hacking. It's important to re-emphasize, Madam Speaker, that the access is not going to be external. It is going to be purely a local access, nothing at all external, nothing direct. So no external authority is going to be able to access this information and obtain this information without making requests through the agreed mechanism to our local agency, which is actually carrying out the search. Thank you.
Honorable Leader of the Opposition.
Madam Speaker, that's what we're very concerned about, the external factors of hacking. Madam Speaker, I have at least 3 questions left. If all the know your client due diligence information in relation to beneficial ownership is maintained on this register and is maintained and is obtained by, that information is obtained by illegal hacking, what kind of guarantees are in place from the British government with regards to identity theft, extortion, blackmail, or terrorist threat? And is Caymanians, is this being applied to Caymanians, or do we understand that this might apply to our information also?
Honorable Minister for Financial Services.
Madam Speaker, the controls around the access of information are controls which exist locally. There are, once the information is provided to the requesting authority in the UK, there are controls around what they can do and how they can handle that information. The parties would certainly be receive the protection of the usual data protection provisions that are relevant in the UK. So I don't see that as being a particular concern. They certainly have greater data protection at the moment in the UK than we have specifically in place in the Cayman Islands. One moment, Madam Speaker.
Madam Speaker, I was seeking to find
Honorable
out,
Leader of the Opposition.
I was seeking to
can
find
you
out in the
just-
same answer that the UK have
Member of
this.
the Opposition, can you just wait a minute, because while he's consulting, he probably may not get your full gist.
I think he was asking the AG the question because of what I asked him without being on the mic, and that is the UK has a protection. How is it going to extend to us? How are they going to protect us?
Honorable Minister.
Madam Speaker, the same regime which has been in place in terms of the sharing of information through the established tax information exchange agreement regime will apply in this context as well. In the same way, the same confidentiality, the same data protection, the same issues, the same protections which are relevant to the tax information exchange agreement regime is the same thing that will apply in this context. So those agreements that may have been signed in the past by the Leader of the Opposition, the factors around that in terms of protections are exactly the same types of factors that are relevant and available to parties in this context as well, Madam Speaker.
Honorable Leader of the Opposition.
So, Madam Speaker, the minister is agreeing that maintaining the records with the service provider in the islands in paper form will avoid the risk of criminal hacking.
Honorable Minister for Financial Services.
Madam Speaker, the reality is that corporate service providers in the Cayman Islands all maintain these records in electronic form. So while they may have paper files, they nevertheless maintain this information in electronic form. And in fact, when there's a normal request under the existing regime of the on-request tax information exchange agreements, for example, that information is typically provided in electronic form. So the issues are very similar. Nothing has particularly changed. Madam Speaker, there is no central register as I have outlined, and I've outlined the rationale or underlying the or the concerns underlying the rationale in respect of that.
Madam Speaker,
Honorable Leader of the Opposition.
part A of this question is just a minute, Madam Speaker. Madam Speaker, then what possible disadvantage exists in maintaining that system he's talking about and arranging for the Tax Information Authority to inspect on request? Does he see a disadvantage in maintaining the system he talked about and arranging for the Tax Information Authority to inspect on request?
Minister responsible for financial services. You need
Madam
some
Speaker,
time.
Well, no, I think I need the member to clarify the question a bit further with respect, Madam Speaker, because is he saying that we should not have an electronic system and it should be purely paper, or whether it should be, or I'm not quite sure what he's saying.
Honorable Leader of the Opposition.
If we're talking about full beneficial ownership information is retained by service providers in the islands, and in respect of all beneficial owners or ownership, that's what I'm asking, what possible disadvantage exists in maintaining that system and arranging for the Tax Information Authority on request?
Honorable Minister for Financial Services.
Madam Speaker, I'm still not 100% sure what the members is asking for, but I can't think, if I'm understanding him correctly, I can't think of a specific of a disadvantage in this context. The mechanisms for the sharing of information and requesting of information in the context of the exchange of notes and the protocol, the technical protocol for beneficial ownership information is similar in substance to the protocols around the sharing of information for tax purposes under the tax information exchange agreements. So I am not quite clear. I suspect that I'm not understanding fully his question, or perhaps he's not understanding what he's asking me.
I could have asked it the other way around. I think I asked it just now.
Honorable Leader of the Opposition.
Thank you, Madam Speaker, and I will ask it again. If, as in the case, and I'll ask the question fully, as is the case, full beneficial ownership information is retained by service providers in the islands, then, Madam Speaker, what possible disadvantage exists in maintaining that system and arranging for the Tax Information Authority to inspect on request? And again, I would ask, does the minister not agree that maintaining such records with the service provider in the Cayman Islands in paper form will avoid the risk of criminal hacking? That's what people are concerned about, is hacking, and how much can we protect them against it?
Honorable Minister responsible for Financial Services.
Madam Speaker, if you would indulge me with a few moments to consult. Madam Speaker,
Honourable Minister.
thank you for your indulgence. Madam Speaker, it seems to me that the member, the leader of the opposition, the first elected member from West Bay, is saying that if the beneficial ownership information or or due diligence information maintained on a particular client is held in paper form only and searched in paper form, then that is somehow hack-proof. Madam Speaker, as I've said previously, businesses don't typically operate in this way today. The information is stored electronically. The volumes of information that are involved, it would be completely impractical to have the range of information available on particular clients that are required under our AML and anti-money laundering and counter-financing of terrorism and beneficial ownership information. That would all be very, very difficult and next to impossible to manage in a paper form where you were requesting information. So I don't think that it's a practical perspective to suggest that that is the way to go about it. Certainly, Madam Speaker, in the context of a system which is promulgated by the Financial Action Task Force, which has been supported by the G20 high-level principles that were issued, I think it was last year or the year before in their Brisbane meeting, they certainly contemplate that you would either have a central register which is maintained in electronic form, through which searches could be carried out efficiently and quickly, or there's a similarly effective system. Now, clearly, we could never stand up to scrutiny if we suggest that having a mountain of paper files to search through is a similarly effective system. That is the basis upon which we take the position that as a jurisdiction, we comply with the G20 high-level principles as well as the FATF requirements. To do otherwise would completely eliminate any credibility we have on the issue. So, Madam Speaker, we have looked at the issues and the concerns around this. We have done our public consultation on this issue in the early part of 2014. We've had better than 80% of our industry and other respondents, public respondents, say that the system that we have in place at the moment with our corporate service providers who obtain information, who verify the accuracy of that information, and periodically update that information is the best system, and that we should not have a central register. But clearly, the system, the alternate systems around that are similarly effective that we have proposed meets with their support, and that is the approach that we will be pursuing at this point, unless there is some further development. We've always said, Madam Speaker, that the Cayman Islands are not afraid of complying with global standards, but certainly unless, and that includes a central register, Madam Speaker, but unless it is truly a global standard that applies across the board to all of our competitors, we would be at a disadvantage in leading on this particular issue. And as I said, we do not have the support of our industry, and there are lots of good, very credible, very strong, very compelling arguments why the proposal that we have both recognizes the system that we have in place, the efficacy of that, the efficiency of that, and also recognizes that there are certain risks that are mitigated or minimized in the approach that we've taken. Thank you.
We've reached the hour of 11 a.m. I'll recognize the Honourable Deputy Premier to move the suspension of Standing Order 23, 7 and 8.
Thank you, Madam Speaker. Madam Speaker, I move the suspension of Standing Order 23, 7, and 8 to allow questions to be asked past the hour of 11 a.m.
The question is that Standing Order 23, 7 and 8 be suspended to allow question time to extend beyond the hour of 11 a.m. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Standing Order 23, 7 and 8 is hereby suspended. Recognize the Honorable Leader of the Opposition for his final supplementary.
Thank you, Madam Speaker. The minister says he has 80% agreement that what we have is the best system. That's a good percentage. Hopefully, if anything goes wrong and we start to lose business, that 80% can stay here. Anyway, Madam Speaker, I probably had two questions, but I'll use this last one. Does the minister not agree that having a centralized beneficial ownership register in electronic form available to the United Kingdom authorities only in the overseas territories will act as a serious disincentive to the use of the overseas territories when compared to the complete confidentiality available in competitive jurisdictions, notably the United States jurisdictions?
Honorable Minister for Financial Services.
Thank you, Madam Speaker. Madam Speaker, let me just be very clear. We do not have a central register. We do not have an aggregated, or we're not proposing to have an aggregated database. So the question from the member suggests that that is the case. That's clearly not the case, Madam Speaker. If he will read the exchange of notes and the agreed technical protocol, it will be very clear, or should be very clear to him, that we are not going to have aggregated data in the form of a central register in the context of what is agreed with that exchange of notes and the technical protocol. Madam Speaker, the reference earlier that I made to 80+% supporting what we have was in the context of the public consultation that we did under the action plan that was agreed with the UK in 2013. That was in the context of whether we have a central register or we do not have a central register. So what I'm saying is, and what I have said previously, is that better than 80% of our industry and other respondents have said that there is no need for a central register from their perspective, and what we have in place works very well, very effectively. Madam Speaker, the suggestion that somehow we have agreed something which is going to potentially cause significant amounts of business to leave the jurisdiction is not one which holds any water from my perspective, Madam Speaker. No more so than existed when the government of 2005 to 2009 was seeking to get a quid pro quo, meaning get some sort of return benefit during the negotiations in respect of tax information exchange agreements. And at the time, they were under significant pressure from the OECD to simply go along with the standard version of the tax information exchange agreement, which they promulgated, which was very one-sided. Recognize that there is little benefit to the Cayman Islands in a reciprocal arrangement because we don't have a tax system. This is all one way in terms of the sharing of information. But the new government of 2009 to, I guess it would have been 2013, the first thing that was done in that context, Madam Speaker, was to simply go and start signing the agreements that were remaining outstanding in order to meet the requirement of the OECD, so that there was the 12 exchange agreements in place to meet their sort of arbitrary standard of 12 to avoid being or remaining on this gray list which they proposed. So, Madam Speaker, we didn't have a threat of a list in this case, but clearly what has developed is, and what has been proposed by the UK, is reflected in the G20 high-level principles. It's reflected in the FATF standards, and we have taken the lesser of the two options effectively that are set out in those two standards. And that is, firstly, you either have to have a central register or you have to have a similarly effective system, Madam Speaker. And we have taken the position that we have adopted a similarly effective system. And that gives us credibility around the world, Madam Speaker, in the same way that we have achieved a good reputation and credibility in a variety of other areas. What we have done to ensure that there is protection is that we have not created a central register, we have not aggregated the data, and we are simply going to be accessing this information for law enforcement purposes and tax authorities. Madam Speaker, the reality today is that tax information is exchanged automatically with a variety of countries. It's something like 96 now under the Common Reporting Standard. And certainly the FATCA agreement, the Financial Accounting Tax Compliance Act, was committed to prior to this government being in place. And these regimes, on request under the 36 tax information exchange agreements that we have today, and the new automatic exchange, is very clear in respect of the sharing of information for tax purposes. I've said before, Madam Speaker, that as a jurisdiction, our business is not based on being able to hide or facilitate tax evasion. That's not what our business is about. So clearly, this is not a disadvantage. We are sharing information for tax purposes. Equally, Madam Speaker, and finally, no one can argue that this jurisdiction should not serve and act as a responsible jurisdiction within the global financial arena to help to put down the scourge of corruption and serious crime. That is another significant aspect of the rationale for the exchange of notes and the technical protocol which we have signed with the UK. Madam Speaker, I will also add that there are lots of discussions which are now going beyond that. There is talk of having an automatic exchange of beneficial ownership information, and they have something like 33 countries who have now committed to that as an initiative. So I think the Premier has, in his press conference while I was away, announcing the exchange of notes, certainly indicated at that time that things were probably not going to stand still on this issue, and that was very prescient. That is the case, Madam Speaker. Shortly, within 2 weeks of that, the issue has moved on, and now there's discussion about a different type of platform. That's something that we're considering, but Madam Speaker, where we're at now represents a good position for the Cayman Islands. All of our competitors have accepted the exact same position in terms of the exchange of notes. Granted, that doesn't include the US, but obviously the rules are different. Might is right. We cannot win that argument. Thank you, Madam Speaker.
Leader of the Opposition.
Madam Speaker, the last question, and I thank you for your indulgence. I'm glad that the member added on that little piece at the end, because he went from Europe to everywhere else, all the competitors, without addressing the American position. I don't know if he fully done that to give credibility to the understanding that they are not doing what they are asking everybody else to do, and in no way that we seem to be concerned about it. Anyway, Madam Speaker, just to inquire, that when the technical protocol, the papers they sign, talks about beneficial ownership information in respect of corporate and legal entities incorporated in the Cayman Islands. And it says that the government of the Cayman Islands will establish a centralized platform of beneficial ownership information to be maintained by the General Registry, the Cayman Islands platform. This will provide timely access to adequate, accurate, and current beneficial ownership information on corporate and legal entities as specifically defined in the fourth money laundering directive compared to the Cayman Islands. And just to be clear, Madam Speaker, we are well aware of all the regulation and all the efforts that various governments have put in place to help Cayman reach the point where if 80% say that you're not going to be any problem, well, that's a good thing. We are concerned, though, if the 80% it goes the other way. So in this particular part of the technical protocol, is he saying that what he's talking about, that we don't have the centralized system? You have a centralized platform, and instead of a registry, it's called a platform. Is that what he was saying? That's what you're saying? So you don't think that a rose by any other name is still a rose, right? In this instance. And we say those phrases, but meaning that they will get out of this centralized platform exactly what they wanted to get out of the registry.
Honorable Minister for Financial Services.
Madam Speaker, I think I've made it very clear that what we are proposing under the exchange of notes and the technical protocol is not a central register. It is simply a platform for the access of information, which is maintained as it has been for 15 years now by our corporate service providers. Madam Speaker, the general registry maintains, or the company's registry maintains a system which is referred to as CORIS, which is Company Online Registry Information System. This is a system which facilitates the connection of various corporate service providers who sign up to the system with the General Registry Office. It's a two-way pipeline, effectively, Madam Speaker. They can file documents. They can also receive documents from the General Registry. In the same way, Madam Speaker, what is likely going to happen with this mechanism that is contemplated, this access platform which is contemplated under the exchange of notes and the technical protocol, is that there will simply be an add-on component to CORIS which facilitates the flow of information from the corporate service providers that is maintained by them in their database. They will clearly have their protocols, they will clearly have their firewalls set up to ensure that only that the proper access is provided to through General Registry or through this CORIS component. And similarly, Madam Speaker, there will be controls around the access to CORIS, or to this element of CORIS, certainly, by anyone external. As I said, one of our major concerns is to ensure that this is only accessed locally by our own law enforcement people and not externally at all. Thank you.
Madam Clerk.
The elected member for Northside to ask the Honorable Minister of Planning, Lands, Agriculture, Housing and Infrastructure. Question number 51.
Recognize the Honorable Member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I beg to ask the Honourable Minister of Planning, Lands, Agriculture, Housing and Infrastructure the following question standing in my name. Can the Honourable Minister say if a certificate of occupancy is required for a commercial marina?
Honorable Minister for Planning.
Thank you. Madam Speaker, if the marina includes any buildings, then a certificate of fitness for occupancy is required for the buildings. If no buildings are proposed, then the marina would require a certificate of completion.
If there are no supplementaries, we'll move to the next question.
The elected member for Northside to ask the Honorable Minister of Planning, Lands, Agriculture, Housing, and Infrastructure. Question number 52.
I recognize the honorable member from Northside.
Thank you, Madam Speaker. I beg to ask the Honorable Minister of Planning, Lands, Agricultural, Housing and Infrastructure. Can the Honorable Minister say if planning permission is required to construct a commercial marina? If so, what are the requirements, and do these requirements include dockside water, electricity, and sewage disposal?
Honorable Minister for Planning.
Thank you, Madam Speaker. Madam Speaker, yes, planning permission is required in order to construct a commercial marina. The requirements for obtaining planning permission are set out in the Development and Planning Regulations. The regulations and the building code do not require a marina to have dockside water, electricity, and sewage disposal. However, should the applicant choose to have these features, then they would be reviewed for compliance with the relevant provisions of the regulations and the building code.
If there are no supplementaries, we'll move on to the next question.
The elected member
So-
for North.
Madam Clerk, do you have a supplementary member from Northside? Please proceed.
But through you, Madam Speaker, would the minister undertake to ensure that commercial marinas in the future will include dockside water, electricity, and sewage disposal?
Honorable Minister responsible for planning.
Madam Speaker, the member from Northside speaks with a wonderful world of experience, and I am bemused by the way he crafted his supplementary question. He used the word ensure, but what I will answer him and say, and say very candidly, is I understand the concerns very well, and there are regulations which I hope to get here shortly, and there is the new building code which we are working on to adopt. I certainly will. In fact, I've already asked the Director of Planning and the Deputy Chief Officer to be looking to see how that could be achieved without setting standards that are overly cumbersome and onerous. But I take his point very well.
Recognize the member from Easton.
Thank you, Madam Speaker. Madam Speaker, in those regulations that the Minister says coming, will there be provisions in those for liveaboard boats as well along canals? This is a subject that was thoroughly vetted in 2001, and nothing has happened since.
Honorable Minister for Planning.
Madam Speaker, there is a line drawn for planning regulations and a boat, although it's liveaboard in the water. The view at present is that it is not within the jurisdiction of planning regulations. But just like the member from North Side's point, the member from East End's point is also well taken, because I remember myself bringing the issue about discharging effluent and all of that in the canals. And I still feel very strongly about that. So resurrected it has been, but I'm careful with the answer because it may have to be regulations elsewhere than in the planning regulations. But I do agree that there should be some statute which dictates. I'm being told that the National Conservation Law speaks to it. I don't know what the details are, but so that it is not construed by any means that the answer is being, or that the question is being sidestepped. My undertaking is to find out exactly where it suits best, and I agree totally that there should be some regulations, because I know, and this is not today, that from a long time ago, there were such creatures dockside in canals, and effluent was simply being disposed.
Member from Easton.
Thank you, Madam Speaker. Madam Speaker, Friday, I believe we had a lengthy discussion in here surrounding passage in canals and whether or not they required planning permission to build docks. Can the minister say when docks are being built, they get planning approval, since it's not on the Queen's Bottom and it's a construction? Is there, especially when a house is not built there, is there provisions made in those approvals for those docks to say that if it's a livable boat, that they must make provisions for sewerage?
Honorable Minister for Planning. Honorable Minister for Planning.
Thank you. Madam Speaker, my understanding is that if there is no structure on the property and it's a canal lot and there is an application for a boat, a dock, forgive me, a dock, that the Central Planning Authority attaches conditions onto the planning approval which speaks about commercial activities, and we will also ensure that the business of effluent is addressed with those planning permissions. But I think back to the original question, we need it via some statute, not just the CPA making it conditional. So I again give the undertaking that we will determine where it is. You see, the member from East End, as I understand his question, Madam Speaker, is there is a dock that has to be applied for that gets planning approval. But a boat, you can't, if the dock is being applied for The liverboard section of it, as twisted and turned as it may seem, because it's in the water, calls for what I'm not sure about. So I don't want to commit that where it's going to be is all I'm saying. Might seem easy to you, but from what I'm hearing, all I'm really saying is that wherever the correct statute or wherever the statute should be placed correctly, I think we can undertake to ensure that it is done. What I don't want to say to you is that it'll be in planning regulations. If that's where it can work best, then that's fine. That's all I'm saying. So I'm not trying to say no. I'm just, because the Port Authority may be involved, I mean, it's just that there may be other agencies involved. So no matter what is said or no matter what is asked, it's going to come back to what I just said. That's all I'm saying.
Member from Easton, do you have a follow-up?
Yes, Madam Speaker. Madam Speaker, I'm wondering, I want to say surely, wondering if the minister haven't recognized and agreed that when a dock is applied for, there are conditions attached, because the planning law allows the authority to attach conditions other than those in the planning law based on the circumstances. And when those conditions are applied for affluence, do we follow up on it like we have enforcement officers in planning? Do they follow up on it? Because, Madam Speaker, there are a number of these boats, people just come in on them and live on them 10, 12 years, and it goes straight into the canals. Certainly, we must have some control over living conditions. Yes, some boat has, Madam Speaker, toilets, but the fact is they don't have a holding tank. And if the holding tank, it's probably for a day or two, which is what is expected to be in port, and they are pumped out. So, Madam Speaker, I'm wondering if we follow up on follow up on these things to see if those conditions are being adhered to.
Honorable Minister for Planning.
Madam Speaker, it comes back, as I said before, it comes back to what I'm saying now. The CPA, the conditions of the CPA, what I didn't say was that CPA now does it. We're saying that the Director of Planning will be discussing the matter with the CPA to ensure that those conditions are placed there. But I personally don't believe that that's enough for belt and braces. And even if the conditions are placed there and the enforcement officers are checking on it, I'm saying that I believe that there should be some statute which specifically speaks to liverboards and the conditions under which a person is allowed to tie up alongside a dock and have such vessels as a liverboard, because it might not just be effluent that we're looking at. There may be, well, exactly my point. So that's why I'm saying that I hear all that's being said, but just simply having the CPA place conditions, in my view, is not enough. And I'm saying we need a specific statute with all of the various things thought through properly, and that should be in place so that anyone who intends to utilize a liverboard for that purpose knows full well exactly what conditions under which they can live there.
If there are no further, member from the north side.
Thank you, Madam Speaker. I wonder if the minister could say if the most recent commercial marina built for the Port Authority by a private developer had planning permission and has in fact obtained a certificate of occupancy for the building and a certificate of completion as given in a previous answer for that marina.
Honorable Minister responsible for planning. Honorable Minister for Planning.
So, Madam Speaker, because there was a building involved, a certificate of fitness for occupancy was issued on the 28th of April 2014. When you issue a certificate of fitness for occupancy, that is for the entire project, but once you issue a certificate of fitness for occupancy, there is no requirement for the certificate of completion. Certificate of completion comes before certificate of occupancy. In other words, you could have a marina which did not have a building, and all that would require would be a certificate of completion. The fact that this one had the building, it required a certificate of fitness for occupancy, which it received on the 28th day of April 2014.
Member from North Side.
Through you, Madam Speaker, can the member say when the CPA was granting the certificate of occupancy for the building, whether any consideration was given for the people who were going to use the marina side, which doesn't have a certificate of completion, and he said that's not necessary once you get occupancy for the building, by people who need to meet the Port Authority regulations of having holding tanks, and the Port Authority is building a marina itself and providing no facility to pump out the holding tanks that it requires.
Honorable Minister for Planning.
Thank you, Madam Speaker. This supplementary comes back to the same original point. Because there is no statute which requires them to, it wasn't done. But I will stand here and say, and the minister who is in charge of the Port Authority is to my left, sitting very quietly, but I know he's anticipating. I am saying that such a location should and must have a lifting station in order for those boats to be able to pump their effluent. So I am certain that the minister will be looking at that in order to ensure that it's done. And it was unfortunate, but I have to be truthful, until the member just brought it up. I didn't know, because I again remember being over there when they were talking about this years and years ago, saying, make sure that that is included in it.
Member from North Side.
Through you, Madam Speaker, one of the ministers, with the minister would commit to, in the process of seeking the help of the minister responsible for the Port Authority, to retrofit the sewage disposal, if he would also ask him to retrofit water and electricity. Because if you go down there, it's like a snake yard with hoses running from the building. The boat owners have to run hose from the building, which has water to it, to different sections of the top to get water. And it really reduces the ambience, the effectiveness of the marine, and it's a total waste of the existing condition.
Honorable Minister.
Madam Speaker, the minister who is the Honorable Deputy Premier who is sitting to my left, I am sure has very good hearing. I'm sure he's heard what I understand the process, what the member from North, I'm sure he heard what the member from North Side has said. What I will say about that, with a little bit that I know, is there's always a question of who is going to pay for usage. So I am sure once those matters can be sorted out, that can be done also, but notwithstanding anything else, Lifton Station is of paramount importance, and I am certain the minister will be looking at it to see how best. I've heard on more than one occasion the talk about that, minister from Northside. I don't want to say things that I'm not 100% sure of, but I'm sure this will revive the talks again. Thank you.
Madam Clark, next question.
The elected member for Northside to ask the Honorable Minister of Planning, Lands, Agriculture, Housing and Infrastructure. Question number 53.
Recognize the honorable member from Northside.
Thank you, Madam Speaker. I beg to ask the Honourable Minister of Planning, Lands, Agricultural, Housing and Infrastructure the following question standing in my name. Can the Honourable Minister confirm that the company Wharton Smith, contracted by the Water Authority to repair the sewage lines, has been allowed to import heavy equipment such as excavators, rollers and front-end loaders to work on the job?
Honorable Minister responsible for infrastructure.
Madam Speaker, I am absolutely certain that the member from Northside is going to be listening very carefully to the answer. It is correct that Wharton Smith Inc. has brought in equipment for this project. But, and let me preface what my answer by saying this is information that we have received from the Water Authority. But this is specialized equipment to ensure the work can be completed in a timely manner. And the reason for that, Madam Speaker, is any disruption to traffic flow on roads and such the like. Progress to date has proven this, and it is anticipated that the entire project can be completed at least 1 month ahead of schedule, significantly reducing the inconvenience to the residents along the pipeline. The excavator has an extended boom to assist with the pipe installation. The front end loader is dual purpose, bucket and forks, to assist with moving long, that is in excess of 200 feet lengths of fused 24-inch diameter HDPE pipe into the trench. The Water Authority typically follows the procedure as outlined by the Department of Vehicle and Drivers Licensing for importation of heavy equipment into the Cayman Islands where it relates to permanent importation. The application form is completed and submitted with a processing fee to DVDL, after which it is processed by the Ministry of Plahi. The situation for contracts with overseas contractors is slightly different. Although the overall majority of the contracts that have been awarded by the Water Authority have been to local contractors, there are certain specialized contracts for which overseas expertise is required. With respect to the importation of specialized equipment, the Water Authority writes to the Customs Department advising that a contract has been awarded and that the contractor will need to import various pieces of equipment and materials for the sole purpose of facilitating this project. The Water Authority then requests the Customs Department to allow the contractor to temporarily import the necessary equipment for the duration of the project without the payment of import duty or the requirement to obtain a customs bond, as this equipment will be re-exported upon completion of the work. Once the waiver has been received from customs, the equipment is temporarily imported. The Water Authority was not aware that DVDL and/or Ministry of Plahi needed to give approval for the temporary importation of heavy equipment. The procedure has been followed for at least the last 15 years. It must be noted that the contractor's decision to bring in their own equipment is based on practical and economic considerations. And those are, is the equipment necessary to complete the job in an efficient manner readily available on island? Is the cost using the contractor's own equipment, including the resources needed to complete the paperwork, etc., less than the cost of hiring locally available equipment, taking into account the expenditure related to the shipping of the contractor's equipment to and from the Cayman Islands, and the unavailability of the same equipment for other projects during the shipping period, which includes a significant time at the respective ports. Excuse me. Overseas contractors are also advised that they must comply with all applicable Cayman Islands laws relating to employment, including the labor law, latest revision, and the immigration law, latest revision. On this contract, Wharton Smith has taken all reasonable steps to ensure that local labor is utilized wherever possible. They currently have employed 4 staff through Bill McLaughlin's East End Labor, 2 to operate the equipment, 1 for general labor, and 1 for traffic control. The contractor has also employed 2 local dump trucks with drivers to haul material to and from the site. Additionally, during the crossing on S to the Tibbetts Highway on Sunday the 7th of February, a locally sourced excavator was on site throughout the day as a standby.
Recognize the member from Northside.
Through you, Madam Speaker, can the minister say
This is an appropriate time for the morning break.